opinion on what is releasable and or maybe not releasable due to Garrity considerations primarily. Defense counsels have filed various motions or their opinions on releasability of certain things. I think Your Honor has all of those motions and everybody's opinion on it. I turned over to the court this morning the binders of all that information for the court's review. So I think it's probably that issue is at the point of the court's review now. I think the expectation is probably a report date on that for Your Honor's ruling, or if you need more from the parties, for Your Honor, let more from the parties. That may be something that happened quicker than the rest of the information that Mr. Single's requesting.
Defense counsel, is there anything else you wish to add? As far as the responses to that June 5th deadline, has everyone had an opportunity to file any responses that they wish to file on those?
Yes, Your Honor. Yes.
We're going to use today as a deadline, and seeing that everybody has had an opportunity to respond, I have received the responses from different counsels on those. I will look over those responses. As far as a time to come back, we hadn't got everybody's calendars previously and discussed the date. Do we know how far we need to go? I know you said about 45 days for the discovery to be complete.
Maybe one of those first weeks of August.
We're looking at August 11th.
Not that I'm necessary, but I'm supposed to be in Nashville at a conference for the trustees office for the 10th and 11th. Yeah, I'm Zoom off for this meeting. But I don't want to hold up the court or the other lawyers. I can come back early.
No, but is August 7th.
Your Honor, I'm going to be in Kansas City on mediation for that case.
The court's looking at that second week of August. If we can't do that second week of August, we can do that third week of August. But we need to try to coordinate and get our calendars together in order to find a date on those. Defense counsel, if you all can look at your calendars or with the state quickly, and we can try to figure out a date that would be amenable to this calendar.
During that week, starting with the 14th, I do have a trial in the school in the building, but I'm sure we're going to allow some time for whatever the board of 14 needs.
I'm also available that week that Mr. Perry's talking about.
Maybe the 17th or 18th of that week.
That works for everybody.
All right, August 18th.
August 18th.
Yes, sir.
All right. We will show this matter reset to August 18th. We'll have that as a tentative deadline as far as trying to get the discovery completed on this. In the meantime, the court will review those documents, review the responses. If we need to have a hearing on that, then I will have the clerk reach out and we will schedule a hearing, either have it on that date, or if we need to do it prior to that date, then we can set that prior to that date. But we will use August 18th as our comeback date, and hopefully at that time we'll be able to have the discovery finished.
Your Honor, for that August 18th date, as we can see what is required when people come to court, could I ask that the defendants not be required to appear on the 18th?
At this point, why don't we anticipate the discovery being completed? If it does in fact look as though the discovery will complete, we'll have the Is there any other matters that we need to bring? Let's close the doors. All right. And I did notice that there were some other individual motions that were filed by some of the defense counsel. If there is a hearing date that is needed on those respective motions, please contact the clerk and the state. We can set hearings on those as well.
Now, pursuant to your rules, your chambers have received copies of the motions, and those are the motions you're talking about. It's my motion to sever, motion to fill particulars. And so I prepared this, but I really frankly didn't know who to give it to, for your honor. But as it relates to a hearing, Mr. Hagerman and I agreed that we're going to discuss what's contained in my bill of particulars to see if a hearing is necessary. Is that right, Mr. Hagerman?
That's correct.
There's no sense wasting the court's time, Mr. Hagerman. I can talk about it.
Well, that's what the court is, I guess, just indicating. If you all speak and we need to have a hearing on any of these other motions that have been filed, we can just give it to the clerk and schedule those motions.
Likewise, I think I'm in the same position as Mr. Zumack and his client on behalf of Mr. Bean. What I was thinking though, as there was a mention about an index of questions regarding additional discovery, I might hold on one time to get a date prior. It's courtesy copy now.
All right, well then we will show this matter reset until August 18th. At that point, we do anticipate the defendants being present, but if something changes, we will send word to counsel that the defendant's presence will be with. All right, thank you all for being present.
Thank you.
Thank you.
Thank you.